If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, attorney Shah Peerally can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shah Peerally is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shah Peerally, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
Beerables Inc. is an e-solutions company that provides custom web design, web application development, and internet marketing services to individuals and businesses. They can build powerful e-commerce sites, mobile apps, develop content, and market you on social media. They can help manage your brand's reputation and provide rock-solid customer support. Call today at 1-800-651-6091 or email us at info@beerables.com for a free consultation today. Again, the number is 1-800-651-6091.
The Shah Peerally Law Group and IMI Law Help, Inc. are proud to announce the release of the Immigration Law Podcast on iTunes, Google Play, TuneIn, and other renowned podcast channels. Immigration Law Podcast was designed to provide the audience with information on various U.S. immigration issues. The podcasts are unique because they are presented by the prominent attorney, Shah Peerally, covering topics such as B-1, B-2 visas, visitor and business visas, H-1B visas, L-1 visas, O visas, EB-1 visas, student visas, perm labor certifications, national interest waivers, NIW, green cards, and citizenship. Although educational in nature, the podcasts provide a rare insight on immigration news and politics from an experienced lawyer's perspective. Immigration Law Podcasts, a unique perspective on immigration law. Download them from iTunes or Google Play. For more information, visit attorneyonair.com or call 510-742-5887. This is just an advertisement. No attorney-client relationship is created by this ad.
The new novel, The Immigration Lawyer Asylum, has something for everyone: drama and romance. The story is inspired by a true story about a man from Iraq who is a suspected terrorist and wrongfully held by the U.S. immigration. The story is centered on the immigration lawyer, Sarah, who handles the case and describes the entire immigration process to obtain his freedom. The story goes in great depth on filing immigration petitions. If you're a reader who wants to curl up with a book about immigration matters and human rights, visit Amazon.com to buy. Visit www.splgpc.com. Call 510-742-5887.
If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, attorney Shah Peerally can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shah Peerally is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shah Peerally, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, sastikal, namaskar to all the listeners. Today is the Shah Peerally Law Show and we are live today. It's June 15, 2017, and I apologize if we are having some issues on the line, but today we are trying our best. Thank you, Franco, for really kind of putting things together for us today. And the studio line will be open in a few. The number is 408-912-5565, 408-912-5565. And again, everything I'm going to tell you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office, 510-742-5887, 510-742-5887. And we're going to be opening the lines ASAP because I know we are trying our best to kind of resolve some technical issues on our side, so we apologize for that. And also, ladies and gentlemen, of course, the news on immigration, it's not great news. We are seeing, unfortunately, a crackdown on a lot of H-1B cases. We are seeing right and left notice of intent to revoke. And what is a notice of intent to revoke? Because a lot of people get confused of intent to deny, notice of intent to revoke, denial, RFEs, you name it. There are different types. Each one are pretty much issued around the same kind of format, but they have different implications. An RFE is a request for evidence, which everybody knows about. What it does, it actually gives you a chance to get information on a case, gives the USCIS a chance to get information on a case, and that's when they request additional information to make sure that they can complete your case. Now, a notice of intent to deny is when a case is pending and they are not agreeing and they have a strong case that they are going to deny this. What they will do then, they will give you a chance to respond. And that's why they send the notice before denying that, because under the law, they don't directly deny a case. They give you a chance to basically respond. We have seen many cases where both RFEs and notice of intent to deny, we basically answer them, and you end up by winning them. Now there's a third one, which is notice of intent to revoke. What a revocation means is technically USCIS is taking away your H-1B. For example, or any other visa. What it does, it's after approval that they issue that, and also, I apologize, after approval they issue that. That means they approve the case, but then later on they find something, or they investigated the case, or something is not right, they approved it wrong. They come back and they file this, they send you this notice of intent to revoke. What it does is basically, if you get a notice of intent to revoke, is basically they're revoking the entire H-1B, for example. That means if you're cap exempt under that H-1B, if they revoke it from the original, if it is the original H-1B that is being revoked, that means it's as if you never got the H-1B. And that's where it becomes really kind of heartbreaking, because someone can be on an H-1B for a while, and then suddenly they take away that H-1B, and once they take it away, you won't be able to transfer, you won't be able to benefit from the cap exempt. And unfortunately, now they even add a situation where basically they can add fraud or misrepresentation, which ultimately can become a bigger problem for you. So for those who are basically kind of facing those difficulties, please give us a call, because each of those cases are very different. There's no blanket notice of intent to deny, but there is a pattern that is kind of starting now. For example, programmer positions, level 1 positions, cases where if they find out later that the original end client or the original in-house project was not really strong, they are doing that. So be ready for that, unfortunately. And unfortunately also, if that is happening to you, I recommend that you hire a lawyer or have your lawyer work on the case ASAP to protect that H-1B. And we are seeing this more and more often now, unfortunately, and that's based on those executive orders coming from the administration cracking down on H-1Bs and on other visas. So be ready for that. And that doesn't mean you're done, but you should be ready for that. Let me take one caller. This is Shah Peerally.
Hi,
Hello.
Hey, Shah. I have a question about if it's okay to contact ombudsman on if USCIS hasn't done anything on the priority date retention request from a revoked I-140.
Yeah, it is. But let me tell you how it works for the priority date. Technically, a priority date doesn't go away unless the I-140 was revoked for fraud or misrepresentation. But there is a case law, one exception, and it was a BIA case law which says once an I-140 is taken away, withdrawn, you're not eligible for the priority date. But that case law is not a strong case law. Now, if your question is contacting the ombudsman is a good idea, yes. But unfortunately, right now, under this administration, I don't know how fast the ombudsman is basically working on cases. But yeah, it is something that you might do. Yeah. What happened in the case?
My employer contacted USCIS a few times, and they said that they didn't do anything in the first place, and then I think one of the officers probably told them that this is impossible, that the priority date from a revoked I-140 to carry forward.
Yeah, but we need to know what was it a full revocation from USCIS or was it a withdrawal from the company?
So the case status says revoked, but it was a withdrawal from the employer's sponsorship.
Okay, but it was not revoked for any fraud or misrepresentation, right?
No, not for fraud or misrepresentation. Yeah.
Okay. So what you can do, you can also refile and reclaim that priority date through a letter again and kind of see what was the reason they're denying. Did they say a reason they're denying that priority date, or they're just ignoring you? They're not giving an answer?
No, it's been a year. They just haven't responded. They responded once, but there hasn't been any update. They didn't issue an amended I-140, so I don't know if that they just updated their system, but nobody wants to. Nobody in USCIS is telling anything or issuing a new I-140.
Okay. One thing you can do, you can check with a congressman and see if they can kind of update you. Try that. And you can also put an ombudsman claim. But from my experience right now, the ombudsman is so overwhelmed that their response is really low. And they're not responding kind of case by case. They're just going into general situations. But one of the things I would recommend is to contact a congressman, ask them if they can intervene for you and claim your priority date. In the meantime, you can also put a complaint with the congressman. Okay?
Okay, sounds good. Thank you, Shah. Thanks for help.
Good luck to you. Let me take a caller. This is Shah Peerally. You're live on air. Hello? Hello?
Hello, can you hear me? Hello, can
yes,
you hear
I can
me?
hear you. Go ahead.
Thank
But
you.
speak a little bit louder, please. I think you're on Bluetooth or something.
Sure. So this is Shubha here, and I have a quick question for... my brother came on a green card as he was minor when I applied for my brother's son came here. I applied for my brother and he was minor, so he got green card as well. So he's here on green card, and now maybe he's... so my question is, if my brother don't want to continue his green card, but his son is here who has a dependent green card, so would he can stay here, or how that works? And can you please guide me?
Yeah, because the son already claimed his green card. He came here. So if the father wants to leave the green card and go, the son, if he stays here and he becomes emancipated, or the father doesn't force him to go, he's still a minor, right?
He's not minor anymore.
Okay, then he's fine. He can stay. His green card is his. It doesn't matter the father loses it. He keeps his. As long as he stays, he doesn't break it. Break the timing. He should be fine to stay. Okay?
Okay, and just one more thing. And now that son is planning to get married. So his wife will get green card right away, or she needs to wait for a while, and what's the process for that?
Well, if the son already got his green card, he gets married. It takes around 1.5 years or 2 years for the green card holder to bring their spouses. Unless he becomes a citizen, then he comes pretty much within 6 to 8 months. Well, 8 months to 1 year. But no, it's not a problem, because if the marriage happened before he got the green card, he entered here, then it's a problem. But if he's not getting married after that, there's no problem. He just bring his wife like a regular green card holder. Okay?
Okay, sure. Thanks.
Good luck to you. Let me take another Franco. This is Shah Peerally. You're live on air.
Hello, sir. Good morning.
Good morning.
Hi. So I have a question regarding the recent rule change, which is applicable from Jan 17 regarding I-140.
Yes.
I have my I-140 approved in Jan 25th or something, and I just want to be clear about the rule. Like, let's say after 6 months of my approval, and there is no notice of intent to revoke or something, can I just change companies and then not apply for I-140 with the new company until I get my green card? Is that so?
No, that's not the law. The law only protects the I-140 for you to use for extension of H-1B or getting H-4EAD for your wife. But if you move to another company, you still have to file a labor certification, plus then you can borrow the priority date. People are confused. Just because they are maintaining the I-140 doesn't mean you can use it with the next company. The only time you can use that I-140 with the next company is if in a situation where you have what we call basically an I-45 attached to it. Then under AC-21, you can carry this forward in the same or similar position. But just the I-140 is not transferable, only the priority date.
So the EAD will still be valid, right?
Okay, do you have an I-45 attached to your case?
No.
Okay.
The EAD for the H4?
I-45 means adjustment. What EAD do you have?
H4 EAD for my wife, is it still, will it still be valid?
The H4 EAD, you can still use it if you do your transfer of H4 properly. You can still use that for an extension of H1B beyond 6 years, but you cannot use it to get a green card with company B. Let's say you got it from company A, the I-140. You cannot use that to get a green card with company B. You can only use the priority date. You can use it to extend your H1B. You can use it for H4 EAD for your wife. But if you want to get a green card with company B, they have to start your labor certification, get another I-140, and take that priority date. That they can do, but you cannot use the same I-140 to get a green card.
I-140? Is it after? I mean, if it takes 10 years to get my green card, if I file I-140 just at 9 years, is that fine, or do I need to file as soon as I get into the company?
I would recommend filing it as soon as possible, but you don't have to hurry as long as you have the I-140. But remember that rule of protecting the I-140 is an Obama rule, and if Trump start getting more attacking all those rules, then that administration can do, they can take away that rule. And once the I-140 is gone, you'll be stuck to extend your H-1B, because that H-1B is really relying on that I-140 to keep extending after 6 years. So to be on the safe side, I would recommend filing your I-140 with the new company as soon as possible. Okay? Okay?
Yeah, sure. Thanks.
Good luck to you. Let me take another caller. This is Shah Peerally. You're live on air.
Hello, sir. Thank you so much for taking my call. So my question is, me and my spouse, we used to work in different states. I used to work in California, and my spouse, she used to work in Arizona. And her current job ended, and she applied for a H4 visa as my dependent. And when filing for H4 visa, she provided her Arizona address as her mailing address and as her residence address. And her H4 got approved now. Now I'm planning to apply H4 EAD for her. So when applying for H4 EAD, can she still use her Arizona address, or since she is a dependent on me now, she should be using my California address?
No, wherever she's living, it's fine. As long as you're genuinely married. If she's living in Arizona, you use Arizona. If she's living in California, she uses California. Wherever she's living.
So even though she's my dependent, she's not obligated to stay in the same address as mine. Is that right?
No. No, you don't have to. But if they believe, but it can be a factor for them to question the marriage. But if your marriage is genuine, it's just because of your work, you're living there, then you don't have to worry. It is a factor that they use to question people's marriage. But apart from that, no, she can live in a different state because of her work. She can easily explain that she has to live in another state. People do it all the time now with the new world. Couples are living separately, not separately in terms of legal separation, but separately in terms of physical, because they need to make a living, right? So, no, it's not a problem. As long as you're genuine, you're not lying, you should be fine.
So my only concern is since her current job ended and the current job which she used to do in Arizona ended, and she's more of dependent on me. So my concern is
she's already dependent on you on the H4. The H4 is a dependency. The EAD has nothing to do with the dependency. The way it works, H4 depends on H1, and then EAD depends on H4. So since the H4 was approved, the EAD has nothing to do where address you put, but you need to put the exact address where she's living, because if tomorrow they come and visit, if they don't see her there, then they might question your marriage. So you just use the address of Arizona. It should not be a problem. But they might ask question, how come she's living there? Then you'll have to explain that she has work there. That's why she's living there.
Yeah, even though her job ended in January this year, she can still stay in Arizona, right?
Yeah, she can, but they might question why you're not going back to your husband. That's a different issue. But legally, yes, she can file. There's nothing wrong. But if she's, it's hard to ask those questions on the radio. Give me a call maybe at the office. We'll do a private consultation, because I want to get all the why she's staying in Arizona when her job is ended, okay? Because you don't want us to start questioning your marriage. Give me a call, 510-742-5887, okay? That's the number.
Thank you so much.
Good luck to you. Let me take another caller, Franco. This is Shah Peerally. You're live in here. Hello.
Hello, good morning. Thanks for taking my call. I have a quick question here. One of my friends is on H-1B, and he has to go to India for some personal reasons for 3 months. So can the family stay here, the dependents, the wife and the kids?
Yes. As long as the H-1B is not revoked by the company, yes. But does he have to go for stamping? Yes,
right. He has to go for stamping.
Okay. So if he goes for stamping, they deny the stamping, he's still okay until they revoke the H-1B. If they revoke the H-1B and they don't grant him the H-1B, then the H-4 also will be gone here. So the risk is the same as an H-1B, but there is a bigger risk because at the State Department, U.S. Consulate, you know what's going on right now. So they're a little bit more tricky. But if his job is good, everything is good, then he can go ahead and go get his stamping. But ultimately, it will depend if the H-1B is revoked or not. If the H-1B is revoked, then she will be fine. Okay. If the H-1B is not revoked, I mean. Okay.
Yeah, H-1B is not revoked, and then the family is there, so he'll join them, and then but he has to take care of some other things there, so he'll be there for 2-3 months. So that's where if the family comes back, would there be any problem, kind of a thing, for 2-3 months if they're on their own? How does the law say? So that was the question specifically, I would say, Shapir.
Yeah, like I said, if the H-1B is revoked, then the H-4 is gone. But if the H-1B is not revoked,
as long as the H-1B is valid, then they should not have any problems.
Not valid on paper is not good. We have to know what the USCIS is doing. USCIS, for example, if the company, when he leaves, the company get upset, they say, we don't want you to work there anymore. They send a letter canceling the H-1B. The day they do that, H-4 will go away too. So, of course, there's a grace period if this is terminated. But in the meantime, technically, it goes with the H-4. So it's a case-by-case basis, but technically, as long as the H1 is good, the H4 is good. Okay?
Okay. Thank you very much.
Okay. You're welcome. Let me take a caller. This is Shah Peerally. You're live on air. Hello. Okay, so ladies and gentlemen, we had a lot of callers back to back, and even with us, I hope the sound was good, Franco. So for those who want to call, we still have some time. We will still be taking calls. 408-912-5565, 408-912-5565. We're talking mostly about employment-based immigration because that's where I'm getting a lot of questions. But at the same time, I understand that immigration has a lot of avenues and at the same time a lot of possibilities. For example, someone might have a family petition, an employment-based, a U visa, a VAWA petitions, you name it, and we can help you on those too. For example, you want to petition for a spouse, you want to petition for a child, you want to petition for someone has been abused, and we can look into all those visas for you. You don't have to limit yourself. And again, let me take another caller. This is Shah Peerally. You're live on air. Hello.
Hi, Mr. Shah. Thank you for your show and the education that you bring to the community.
Thank you so much.
I have a question about the H-1B stamping.
Yes.
So, do you know if they are still doing the Dropbox or?
Yeah, they are still doing. I'm getting mixed messages on those myself, but they're still doing it. But more and more, they're kind of limiting it. So, ultimately,
the condition for go ahead.
Yeah, go ahead.
The condition for Dropbox is the same employer and same status, right?
Yes.
Okay.
And no problem. Okay, not only that, also no problem with the law, no other issues on the H-1B. There's no investigation on the H-1B. So technically, they will tell you themselves when you file if you're eligible for Dropbox.
Oh, when I file, they tell us. Okay, when I file the DS.
Yeah, the DS. Yes.
Okay. So I also heard that they're calling people for interviews and technical questions and stuff like that, like related to the job. Is that true, or?
Yes and no. What they're doing a lot, this is a very good point you brought up. I was going to mention that. That's what I was starting earlier with notice of intent to revoke. They're doing a lot of site visits. Any minor glitches on the LCA. For example, someone say, I'm working on this street, but they're working on another street. They are coming back and saying, why did you not file an amendment? Why did you not do this? Why did you not do that? So site visits are becoming really, really a big thing. But yes, I had heard and I have personally heard of few cases where people are questioned at the U.S. Embassy and at the U.S. port of entry about the technical position. They ask them very details about the patents. Basically, they're questioning if those people really have the knowledge what they claim. But I've heard that only in 1 or 2 cases. It's not. But site visits, we are seeing it pretty much on a daily basis now. So that one you have to be careful. But yes, they are questioning everything. Every single thing they can question on, they're questioning. So be ready for everything. Okay,
got it.
Good luck to you. Yeah. Let me take a caller. This is Shah Peerally. You're live on air.
Hi. I have a question for my green card. So my I-140 is approved in October 2014, and I think whenever you start your program, you talk about the status and the different categories. So mine is filed in EB2, so just wanted to check with you. I know it will take like a long time, but is there anything that like you can give me an update, like anything that you know?
So you mean the priority date when it will be current? That's what you're asking?
Yes.
I honestly, I used to do predictions. I'm not doing it anymore. The reason for that is I really don't anticipate a lot of good happening. I'm so focused really on kind of protecting what people have right now. But I think I'm hoping that it will continue moving the same trend. And right now, there was not a great move. I think it's moving like 2-3 weeks every month. So if we put an average of 1 month per case, we are going to see the same trend right now. I think right now is July 2008, and it will go around by up to October. It will move probably to like September 2008 or November 2008. And then if I want to, hoping October 1st, when the new fiscal year, we might see a jump or we might see a retrogression. But I'm hoping there will be at least one jump, maybe bringing it to 2009. Beginning of 2009 by October 1st. But again, this is just a prediction. I might be totally wrong because now it's very hard to predict what's happening because they have completely changed the whole mechanism. So for me to kind of make a prediction based on that is kind of hard. But I'm hoping the fiscal year will bring us some good news. But we have to wait and see. In September, we'll know what's happening in October. Okay?
Sure. And in case if I change the job, then I know there will be kind of refiling for I-140 and labor and everything. So is that like a problem, or is it like,
No, it's not. It's not a problem. But make sure you can maintain that I-140 priority date, and also make sure that you wait 6 months, so at least you can protect your I-140, which you can use for H-1B extension and H-4 EAD for your spouse. So that's pretty much where we things are going to go. But right now, I'm going to be very honest with you. Things are not as rosy as it used to be under Obama. That everybody knows. So even things that we saw was easy back in the days of Obama, now we are seeing difficult in the days of this new administration. And we were expecting that, but so far that doesn't mean everybody is getting denied. We are getting a lot of approvals in the office. I was surprised myself. Last week we got like 7 approvals on cases where we thought it would have been difficult. But still, if the case is prepared well and we don't lie about it, you have good chances. But apart from that, hoping on the priority date right now, I'm not putting a lot of hope. I'm just hoping at least they will not put a retrogression on our head, because we saw a retrogression on EB1 and it's not going away, and that's kind of a little bit worrisome. Okay? But in the meantime, just hang in there. Don't let your I-140 go, because this is your lifeline right now after 6 years extension. Okay?
Sure. Okay, thank you so much. I really liked your show, and you are doing a great job. So thank you so much for everything.
Thank you so much. I really appreciate your kind words. That gives us courage to continue on doing the show. And I just wanted to say thank you for all our supporters and fans, and hi-end thank you to all of them.
Yeah.
So let me take another caller. Good luck. This is Shah Peerally. You're live in here.
Yeah, hi. I have a question on amendment.
Yes.
So it's if the amendment is in process, can I go to my home country?
No, unless you're ready to go back. Let's say you're with company 1, and you are working with end client A, and you did an amendment for end client B. Okay, if you're going outside the country, and if client A will still be willing to take you back on the job, and you have not moved to client B, then yes, you can come back. Do you have stamping on your passport?
No, I have to go for the stamping.
Okay. So if you are going for stamping and you have an amendment pending, they will ask you to wait for the amendment to be approved. Then they will give you the stamp, unless you can prove you're still working for end client A and you have not moved yet to end client B. So be careful on that, because while it's pending, it's in a fluid state. So they won't issue really. I've seen cases where they do issue it, but technically they are not supposed to issue it. Okay?
Okay, and same question on the amendment again. So if I work for the same company, but it's the same companies in different states, like one in Texas, one in California. So if I apply for amendment when I start in California, then I move to Texas, do I have to change? Do I have to apply the amendment again?
Yes.
Even though if I work for the same client?
Every time you move or there's a material change on your case, you have to apply for an amendment. There's no way out of it. So but even an amendment pending, you have to file another one. Huh?
But if I don't move the completely, let's say I work here 30 days, then I work there for 30 days. So in that case, because if they're shuffling between the two places, then what would be
that's a different scenario. What you're talking about here is there's a definition for this. It's not coming to my head right now. If you look at the frequently asked question amendment, they mention that if someone has one place, but you're being sent for 30 days to one other place to check on something, another 30 days, you don't have to do an amendment for each of those places, because that's the nature of your business. For example, let's say you are a civil engineer, right? You need to go on site on this project for only 2-3 weeks to check there quickly, and then your office still at the main house, basically the headquarters. You don't have to do an amendment for that going on that site. That's a quick example. It might not be right because if you go there for a long time, then you have to do it. But if it is a matter of you're going there, sitting there, moving everything there, you have to do an amendment. Okay? So it depends on the nature of the business.
Okay. Yeah. Thank you. Thank you.
Good luck to you. So let me take another. Franco, this is Shah Peerally. You're live in here.
Hi.
Hello.
Hi. Yeah. Hi. Thanks for your time. I have a question. So, the attorney which my employer works with, they didn't file my extension in the premium processing, so they just filed it last week, and my H-1B expires in August. So I want to see if I will be able to travel until my extension is done, if something urgent comes up, or if I want to go for Diwali.
Yeah, it's Diwali time. Yeah, but if you travel before August, technically you should be able to come back. Do you have a stamp on your passport or not?
Yeah.
Okay, but I don't recommend it. I'll tell you why. Because at the airport, when you come back, the CBP might say you don't have 6-month approval. We won't admit you in. Go back. When you get the approval, then you come back. Because I've seen a case like that. So it's risky to travel. You can, but I don't recommend doing it. Okay? Because once you don't have 6 months of 797 in your hand, there's a chance at the airport they'll say, okay, hold on a second. Until we get a finalized approval from the USCIS, we don't have to let you in. So be careful. If you have to emergency travel, you can travel, but I don't recommend traveling. If you can avoid it at all costs. Okay.
So what do you mean by 6 months thing? What
you
is
have
that?
to have a 6 month. Right now we're in June. You have to.
Okay.
You have a solid status up to August, right? It's only 2 months, right?
Yeah.
Okay. If you file an extension right now, you are eligible to stay here under a period of stay. But a period of stay is not a status. So when you come back at the airport, unless the new extension is approved for you, you don't have 6 months on your 797. You have only 2 months on a solid 797. You following me, right?
Okay. So as long as this is not approved, I won't have the 6 months. Okay.
So you can stay here, but traveling is a different story because you're requesting something different at the airport. So that's why it doesn't function the same way. You have a pending status inside, but once you leave, that pending status kind of dies. And what happens when you come back, they will ask you first get an approval, then come back. But I've seen cases where they allow people in because they know there's a genuine extension file, but it's risky.
Yeah.
That's all I'm saying.
Okay.
Good luck.
And can you tell if there's a plan of processing, starting premium processing? Any idea if it will be starting soon?
Well, they told us that it will start back. AILA said they will start back. I think AILA said, don't quote me on that.
Around when?
End of September, that means around October 1st, probably, or September. It will resume in the new fiscal year. But there's no guarantee. Right now, you know how things are going. There's no smooth running on anything. So you need to be patient and just, if you don't have to try. I know a lot of people are going to go on vacation, so I'm telling people, be careful because they might not let them back in, so be careful, okay?
Okay, thank you.
Good luck to you. You're welcome.
Thanks.
Let me take another call. This is Shah Peerally. You're live in here.
Hello, Shah.
Hello.
Thank you for your show.
Yes.
I appreciate it.
You're welcome. Thank you, sir.
I had a question about applying for green card for my parents. It's a two-part question. One is, do you expect any changes with respect to family-based green cards? And the second question is, to get a medical exam for them, is it okay if I get it from a different state, not from the state where I'm currently, where I might apply for their green card? Or does it need to be from the same state?
Let me answer you one by one. Number one, I don't see any changes there. They have not mentioned any changes, but down the road it might happen, but right now, no. Number two, yes, it is okay to get it, but make sure they might ask the question why she's there, but it's not a big problem. But yes, you can use another civil surgeon and get it from another state. It's still valid as long as it's recognized by the USCIS.
Okay. Thank you for the information, and I appreciate you doing the show. It's very informative.
Thank you so much. I really appreciate you guys listening. Let me take another Franco. This is Shah Peerally. You're live in air. Hello.
Hi, sir. My name is Sanjeev.
Hello.
Thank you for taking my call.
Hi, Sanjeev. How are you?
I'm doing good. Thanks. How are you?
I'm doing Go ahead.
Yeah, I have a question about H4 EAD actually. So basically, my wife and I, we both are on H1B right now, and I have a 140 approved with my current employer, and she works for a different employer, so she has her approved I-140. Now, what we wanted to do is she wants to take a temporary break from work. So what we wanted to know is, can she move out of the status? She has an approved 140, but can she move over to my? We want to file a H4 for her. And when she wants to work back again, does she need to do a H4 EAD, or should she do a H1 again? And how does that work?
That's a long question. I don't know if I'll be able to answer. But yeah, all those possibilities are there. She can move to H4 EAD, file it both together, the H4 and the H4 EAD. And if you need help, just give us a call. And the way the H4 EAD works, you don't have to be working. It's not like H1B. You can work or not work, doesn't matter. But you have it pending and you can use it. As for the H1, if you move to H4 and H4 EAD, you can always revert back to the H1 if she has time left on the H1. Plus, since she has an I-140, she can use that and get more extension. So it all depends on the case, and if you want to assess kind of in a personal matter what is better for her, then give me a call at the office. We can kind of analyze it specific to her. But H4 EAD in this case is a good idea, so move for it.
So one question, Shah. So her 140 will not, there's no way they can revoke the 140, right? So once she comes back to H1, if she wants to come back to H1 again, will she fall into the lottery system again, or can she do it any time in the year?
She doesn't fall into the lottery. She's still cap exempt, provided the I-140 is still there. But with the rule of I-140, the I-140 will be there. But how many years to use her H1?
She completed her 6 years, and she is on 140 extension right now.
Okay. Then she needs that I-140 to come back on the H1. As long as the I-140 is there, she's cap exempt. But once the I-140 is gone, then she will need to get a new I-140. But hopefully the I-140 won't be gone because of this new rule. So because H4 is a dual intent visa, so it doesn't affect the I-140 anyway. Well, other visas too don't affect it, but she should be fine. She will be cap exempt as long as the I-140 is alive.
Okay. Thank you, Shah. Thank you very much.
Okay. You're welcome. So, ladies and gentlemen, I won't take more callers now. I don't know if I have a caller right now, Franco. This is Shah Peerally. You're live on air? Okay, I think it's... ladies and gentlemen, I wanted to kind of recap today. Before I recap and before Amit comes in, I wanted to talk a little bit about the other area where we're getting a lot of calls is debt settlement, because a lot of people are kind of getting worried and they have their credit cards maxed out, and they want to get out of those debts, and they don't want to file bankruptcy. And this is where we come in. We can negotiate those debts for you, reduce it to a fraction of its value, and bring it to lower. For example, someone can owe $10,000 on a credit card. We might be able to negotiate it for $2,000 or $3,000. But that's just an example. I'm not saying it happens for everybody. But most of the time, we're able to get a better deal. And the way settlement works is a one-time payment. This is not debt consolidation, by the way. It's not like you come, they put it in a basket, make you pay slowly. No. It's a one-time payment, and you are done, and you move forward with your life. It's kind of helpful down the road because that cleans you and makes you start fresh. So it is a good idea to actually go ahead and file those, get into those debt settlement. And for people who really are kind of choking pretty much with debts, or people who lost their jobs, or people who lost a family member, or anything that is a hardship. Hardship can be anything, like an addition on your family, a newborn, a parent coming to live with you, you name it. Anything we can assess it. And the way we work on debt settlement is a contingency plan. So only when we get an approval, then we go ahead and charge you our fees. So it's pretty much less risky for you and for us. And if you need help, you can call us 510-742-5887, and the website is specific for that, or the blog is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. We can do it for second mortgages sometimes. We can do it for other debts. You just call us and we will assess it if it is possible or not. And usually it has to be attached to a hardship. And hardship, like I say, can be anything. Sometimes people don't even know they have hardship. They have a surgery, they are sick, they lost their job, etc. Can all be hardship where we can actually get you out of debts. And it's a good idea to get out of debts because debts can really destroy your life, and we know this. So, ladies and gentlemen, I wanted to kind of recap before I let Amit continue. So for today, we were talking about notice of intent to revoke, which is coming up really fast on a lot of people. So make sure that you answer these properly, have a good lawyer answering them, and also make sure you don't ignore them. And also make sure when you're filing your H-1B, you have all your paperwork in order. Don't try to take chances. And also traveling, make sure, talk to a lawyer before you travel. We'll be glad to do a consultation for a second opinion if you call us at 510-742-5887. And anything I'm telling you today, I told you today, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And we are in the month of Ramadan, again, Ramadan Mubarak, and there's 10 last days of mercy, and hopefully God will give us some blessings to all, and really we need it right now with all the things happening. So good luck to all, and thank you, Franco. And I think Amit, are you there?
Yes.
Hello. Hi, Amit.
Hey, Shah. Hey, Shah, how are you?
How are you? I'm doing well. So Amit, a lot of people waiting for you to talk a little bit in Punjabi and Hindi about debt settlement and